So here, thinking about evolutionary perspective, it's the idea that humans are biologically predisposed to do things today that our caveman ancestors had to do to survive. So, an example, if humans are violent today, we have a tendency to be violent toward one another. It's because we had to be violent to protect ourselves from animal predators as well as human predators because survival was so very tough. Um, the idea is that um, our choices today uh, are we're almost hardwired to to do things that will ensure our survival. And some of those things may not have been pleasant when we were cave humans, and then of course as we continued to evolve. Um, so again, just an idea. I don't want to spend a whole lot of time on that. How most modern nation states today operate. Most of them, although not all, operate on this idea of due process. Yeah, some countries, like for example in Europe, they don't have all the protections that we have here. Um, so I'm not a lawyer in all other countries, but what I do know of many other countries, even in Europe, not have some of the same protections that we do. Um, for example, this idea of, and this isn't criminal, this just has to do with freedom of religion. That is present in our Constitution, and it is in the countries of most European states or nation states. So the rule of law, early on, it seems as though Plato was the first one to write about it, although there may have been others, we just don't know, we haven't found the texts yet. But it's this idea that there are three elements to due process. One is that a nation, a government, has to recognize the supremacy of certain fundamental values and principles, right? So that these values and principles have to be the guiding force within that society. A new leader can't just come in and say, okay, well, we don't believe in those anymore. We're not going to abide by those anymore. They have to be this guiding principle for that society. Second thing, that the values and the principles, they have to be written down so that can't just claim that, well, you said this, but then the other day I said that, and then he said that it's this, and she said that it's that. They have to be written down so we can keep referring to them and reminding ourselves, this is what we said. This is what the value is. This is what our principle is. And the third is that a system of procedures has to hold the government to these principles and these values. So what we have in the US to do this is what we call the criminal justice process, criminal justice system. All right, so I wanted to, hang on a second. Yes, I wanted to talk about um, Cesare Beccaria. He was an Italian philosopher and researcher, and he wrote a very, very influential tome called On Crimes and Punishment in 1764, the 18th century. And he was one of the very first philosophers and researchers to suggest very strongly that societies had to move away from avenging um, offenses to making people accountable, but doing it in a rational and reasonable way, making the punishment fit. And even during the time he's living, which is the 18th century, that's not medieval, but a lot of the same things are still going on: beheading, hangings, drawing and quartering, with horses, one to each limb of a person, and then the horses, all four of them, each being whipped to go in different directions. And then, as you can guess, the person's body would be pulled apart by the force of the horses running in different directions. And so he argued that laws should be designed to preserve public safety and order, not to avenge crime, which is how things have been done before. So here's an example of what he was making, the arguments he was making. Someone stole a chicken. Well, it doesn't make any sense to draw in court of that person because the offense, stealing the chicken, didn't cause that harm that was so great to society. It caused harm to one person, the owner of the chicken, but it didn't cause this much greater harm to society. And so Beccaria was arguing for societies to punish according to the harm done, not just avenging every offense in the harshest way possible. And his ideas were really groundbreaking for that time. He also argued these things, that the accused should be allowed to confront their accusers. In the past, well, we have this now. You can recognize these are part of our Constitution, the Fourth, Fifth, and Sixth Amendments. Um, it used to be under medieval times that if somebody came and said you did something, you would just be brought before the king and queen and told, okay, well, we know you did this, so here's your punishment. You couldn't defend yourself. It was just assumed that whatever the accuser said was correct. Also, the accused should know what the charges are. Often people didn't even know what they were being accused of. They were just brought before the king and the queen. Okay, here's your punishment. You're going to be beheaded. Well, what did I do? Doesn't matter. We know what you did. And so that's important to know, what are the charges? What are you being accused of? The accused should have a public trial before an impartial judge. Again, used to be the king or the queen, or the king or the queen's subordinate, somebody they appointed to just hear in private the accuser say, this is what happened, and then the person be brought before that the decision maker and be told, okay, this is what you got because you did this bad thing. But to make that public trial, so that everybody in the community can see what you're being accused of and they can hear what the evidence is against you. We still do this today. In the criminal court system, you can walk into any courtroom and you can just sit down and hear what's going on. It's all open to the public. If the accused is guilty, the punishment should fit the crime before, and then it should be applied without reference to the social status of either the offender or the victim. So that if somebody is wealthy or a noble person, just because the accused is a peasant doesn't mean that that person should be punished more harshly because supposedly the noble person was harmed. Versus if the noble person does harm to a peasant, that person shouldn't get off lightly because the peasant isn't very worthwhile in society. Beccaria also, again, one of the very first people to argue that death is a just form of punishment. Um, Beccaria argued so often people are put to death for any kind of offense, when really it should only be done when it's absolutely called for, when it's absolutely something, some crime that was so egregious that yes, it makes sense to do this. But in a lot of cases, it doesn't make sense to put people to death for the things that they have, stealing, for example, or stealing was a big one back then. Murder, maybe murder, but again, it depends on the circumstances. Okay, so I'm going to finish up here with the crime control model and the due process model. Crime control model is this idea that um, community protection from criminals is of utmost importance. That means then that all efforts should be taken to prevent crime. And that means that we have to punish people very harshly, okay? And we have to do it swiftly, and we have to do it with certainty. That is, if we have a law that says if you do X, this is your punishment, then we have to do X. Oh, sorry, if you do X, then Y is your punishment. Then we have to do Y. We have to do Y swiftly. We have to do it with certainty, and we have to do it with efficiency. Can't just wait 2 or 3 years before punishing somebody. Also, under the crime control model, if civil liberties have any real meaning, then you can only have that meaning in a safe and well-ordered society. And appeals have to be kept to a minimum because under the crime control model, the thinking is that the more appeals you have, more time is wasted, not only of the people involved in the process, but of society as a whole. It also means that more money is wasted on these appeals. And it means that there's uncertainty for society because they don't know how someone's going to be punished. They don't know what the resolution to the case is. On the other hand, if you take a look at the due process model, here the focus is on police having to obtain warrants to search. They have to be able to honor that a person has a Fifth Amendment right, and if a person asks for an attorney, then police should no longer question someone because they invoke their Fifth Amendment right. The evidence has to be suppressed if it's wrongfully obtained. So if police do an illegal search, even if the person was guilty, drugs were found in the car or in the home or the weapon or whatever it might be, even if the person clearly was guilty, because the search was illegal, if those constitutional rights mean anything, then that person gets to walk because the police made a mistake. And of course, appeals are allowed. As many as are allowed by law happen. In fact, in California, if it's a death penalty case, the first, actually it's in all the states, the first appeal, if the first appeal is paid for by the state. And in California, that's in all states. And in California, the state pays for the first several appeals. Other states don't, you just get the one. So under the due process model, the concern is more with the integrity of the legal process, making sure that the agents of the government act as fairly as they're called to do. And if they don't act fairly, then the person gets to walk free. The person is given the benefit of the doubt because the state did not act appropriately. And because the state has so much power and citizens have much less power, we have to hold the state more accountable than the individual. So Dan, I'll just leave you with this question about which of these two models you think is the better one.